microphone, sorry about that. As Derek mentioned, my name is Joel Beus. I'm the Chief Legal Counsel for Railroad. Excited to be here today to talk about a couple of topics that are keys for startup companies that each of them will have to address at some point. But before I get into that, the elephant in the room, I am an attorney. I've worked for 13 years, mostly exclusively with other attorneys, for the last 6 months with Railroad. And it's come to my attention in that period of time that lawyer jokes are a thing. And so I just want to get this out of the way. A good Gilbert cartoon. It's even come to my attention that lawyer jokes are somewhat of compulsion for some of my new colleagues. So if you have a lawyer joke that you feel the need to share now, this is the most appropriate time to do that. No? Okay. Bart will pick up the slack for you all when he gets up here. Chris, please.
I had a lawyer joke, but then I got super copyright infringement.
Thank you, Chris. Chris is not a plant. That was very good. Thank you. So now that we've got that out of the way, it'll come up again, I'm sure. Let's talk about the first of our two topics. The first topic is choice of entity. The second topic, which we'll discuss later, is an overview of some intellectual property ideas, and hopefully this discussion will shed some light on these topics and make them a little bit less daunting for beginning entrepreneurs. There are many options to choose from as you're deciding which kind of formation your entity will take. Most of these we do not recommend, so I'll just discuss them very briefly before we move on to what we consider the more feasible options. There's a sole proprietorship. That's one that is pretty self-explanatory. It's one individual running a business, and that's it. There's really no legal distinction between the individual and the business. The upside of that is very easy to form, very inexpensive, simple. The downside, of course, is that you have unlimited liability. There's no shield between the individual and the business as far as the liability. And that's a big downside, and that's a big factor that we should consider in choosing the form that our entity takes. Next, you have a partnership. Partnerships are two or more individuals or entities that group together to form a business and run it. The downside here, similarly, unlimited liability for these general partners. No way around that for a general partnership. There's also an entity called a limited partnership. A limited partnership allows more investment to come in, but still then the general partners will be exposed to unlimited liability. And the limited partnership also is a fairly complicated formation process. You have state filings that come into play. So we don't recommend any of those forms. The next one is an S corporation. This is more popular for a startup entity than the ones we've already discussed, but we don't recommend S corporations for a few reasons, some of which we'll discuss in more detail later. But they have to do with the fact that S corporations, although they are a pass-through entity like an LLC, they're not quite as advantageous as far as taxes go as LLCs are, and they are also not as advantageous in fundraising as C corporations are. So that brings us to the two entities that we do recommend for most startups, C corporations and LLCs. And we'll be talking about those and comparing them and contrasting them in the context of several different factors. And after that, we will talk about why Delaware is such a popular place for corporations. So without further ado, governance and structure. This is an important thing to consider. C corporations, as you probably know, have substantial formalities that they have to observe and adhere to. Otherwise, what can happen is the corporate veil can be pierced, which means that the owners can become liable for the corporation's debts and liabilities. Not desirable. The formalities include forming a board of directors, having regular meetings of the board of directors, having a stock ledger, having bylaws that are adhered to strictly. All of these things are important, and they can seem fairly daunting to a startup company. And sometimes they prevent the company from choosing a C corporation, even though it might be the most advantageous form for them to take. We want to try to dispel that and resolve that concern today to the degree that we can. C corporations are managed not by their owners, but by managers who are usually hired by the board of directors. They report to the board of directors. LLCs, by contrast, are usually managed by the members, which is what LLC owners are called, or members. They can also designate managers to run and manage the LLC. Many fewer formalities are associated with running and managing an LLC, governing it. And that's seen as one of the great benefits, of course, of an LLC. It's just simple. You set it up, and it's you don't have to check all these boxes. You have fewer filings. You have fewer reports that you have to fill out. A wise man once told me that the great benefit of having an LLC is that they're perfectly flexible. You can do whatever you want. The great downside of an LLC is that they're perfectly flexible, and you can do whatever you want. So that's something to think about. There is a downside to that. Next, we have ownership. Both a C corporation and an LLC have unlimited numbers of owners. I would say with the caveat with an LLC, you have some complications when you get a large number of members. It becomes unwieldy and difficult to operate. Ownership in a C corporation is freely transferable. Think of a stock transfer. It's very simple. It's encouraged. LLC is much more complicated. It can be, you may have to get permission in most cases from the other members of the LLC to accomplish a transfer of your membership interest. And in some cases, the departure, death, or otherwise removal of a member can result in the dissolution of an LLC, which is not desirable, of course. And with a C Corp, there are no nothing like that happens when a stockholder sells or goes away from the company. The great benefit of the C Corp for purposes of fundraising, which we'll talk about in more detail later, is that a C Corp can issue different classes of stock, which can become very attractive to fundraisers and to investors. Next, we have taxation. An LLC, of course, is a pass-through entity, which means that the income earned by the LLC passes through to its members and it's taxed to them at their individual tax rates. That's seen as a great advantage of an LLC, and it certainly can be in some instances a great benefit compared to a C Corp. A C Corp, by contrast, is a separate legal entity that pays its own taxes based on its own income. And then it has something called double taxation, which sounds terrible. It sounds like the last thing in the world anyone wants to have. I want to alleviate that concern a little bit, but it does happen. When the corporation pays taxes on its own income, and a corporation distributes dividends and distributions to its shareholders, they are then taxed on income, and that's double taxation. Sometimes a startup might get to this point in the analysis and decide, that's it. Taxation is much better for us for an LLC. So simple and easy to set up and operate. It'll save us money in the short term. Therefore, we're going to go with the LLC. Our recommendation would be to continue the analysis and not stop there. There are other considerations that are important and that should be taken into account in making that determination. One of those is employee compensation. You want to plan for success. At some point, your startup may have employees that you'll want to incentivize to stick around and to work hard. And a way to do that, a great way to do that, is to issue stock options to those employees, which is one thing that a C Corp can do that an LLC cannot do. An LLC can issue membership units to employees, but it's very complicated sometimes, and it's tricky. And the law around that is not as uniform and well known as it is for C corporations. The other thing about C corporations is that they have a wider range of tax advantage fringe benefits that they can grant and give to their employees. Tax advantage meaning that they are tax deductible to the C corporation and not taxed as income to the employees. LLCs can do that too, but there are fewer of those fringe benefits that they can avoid. Okay, so moving on. On this topic, we have an in-house expert, Bart Skalla, who is Railroad CFO, and he is uniquely qualified to talk about fundraising in the context of choosing your entity. So I'll turn the time to him. There's chin deep in cement.
A good start. Not enough cement and not enough attorneys. Joel is our in-house counsel. We also have an out-house counsel. Together they cover us very well, and they provide great expertise in what we are doing. And everything that Joel is presenting here, yeah, you can find on a quick Google search. Go to mylawyer.com or any of these websites, and yeah, you can pull down forms and do this yourself. My best piece of advice is find a good attorney and use that attorney, and you will be served very well. So let's see. With this discussion on fundraising for type of entities, so we'll cover the pros and cons between C Corps and LLCs. Throw one more death nail into the S Corp, in case you're still tempted to consider that that structure. So the main advantage in fundraising as a C Corp is if your business plan contemplates, has as a key success factor in the future, the need to raise venture capital, then you have one choice, and that is to go with a C Corp. There's other advantages, like Joel has talked about. You can issue stock options and employee incentive options to your personnel, and that's a great tool to use for your people. If you are fortunate enough to be one of those very few that can get a meeting with a VC, let alone get VC funding, and then continue to be successful and grow, and there are lots and lots of them, but in percentage terms, it's relatively small. But if you make it through all that and then you're successful enough to do an IPO, then C Corp is the way to go as well, and in one state that Joel will address in just a moment. Now, an S Corp, it's just not a good option, and it brings up a red flag, kind of like if you're selecting a bank account for your own personal, your family's personal banking. You want one with free checking, and they might give away a toaster and have online access and all that stuff. But there's one thing you want above all else. That bank has to be FDIC insured, a member of the FDIC. And that's kind of like what Joel referred to as the gold standard for entity. It is a C Corp in a certain state, and that's kind of the analogy. There are rigid aspects of being organized as a C Corp, as Joel was getting into. It's kind of like there are rigid aspects of traffic law, right? There's red lights you have to stop at. There's stop signs that most of us stop at. There's speed limits that everybody but Darren obeys. And so those are there for a reason. So yeah, there are some rigid things associated with a C Corp, but they're there for a reason, and they're not that rigid. It's doable. You can also organize and fundraise as an LLC, and I have done that. I've been a member, a founder of an LLC, a software startup, and we had venture capital out in the long-term horizon. We did not attract venture capital, and we folded. Not because we were an LLC, but for other reasons. But that's one box to be checked. I've also been a founder of a telecom startup that we started in 2003, shortly after the nuclear winter of communications spending, as they call it. And so prices were low for office space and equipment and people's skills and everything. So we started with angel funding, and we raised a little over $400,000 in the first round. We raised another $100,000, but only to provide some liquidity to the CEO. And then we sold 3.5 years later for $8 million. Now, we were organized as a C Corp, but we ended up not needing venture capital. And we sold in 2007, and sometimes you say, well, if you had held on just a little bit longer, you would have gotten more. Not in that case. 2008 follows 2007, and we know what happened with the economy and everything then. So in that case, we were organized as a C Corp. We didn't need venture funding, as it turned out, but there are lots of other reasons for attracting venture capital, for organizing it as a C Corp. besides the need to attract venture capital in the future. Now, there's a logical step you could take here. You could say, well, maybe we'll organize as an LLC to start because it's faster, it's cheaper, has that flexibility that Joel talked about where you can do almost anything. And that's certainly an option, and a lot of people do that, and then convert later to a C Corp. You may have seen this clip on conversion on Seinfeld.
I wanted to talk to you about Dr. Watley. I have a suspicion that he's converted to Judaism purely for the jokes.
And this offends you as a Jewish person?
No, it offends me as a comedian.
Okay, is Mark here? Where's Mark?
I don't think so.
We actually have a Jewish person on staff, and he was not offended that we used this, but the point is a venture capital firm is not going to be offended that you're not a C Corp because of because of the jokes or because of a lack of sense of humor. VCs do not have a sense of humor. They simply won't be offended. In all likelihood, they will use that as an excuse to pass on looking at you. Not in all cases. Certainly, there's such a thing as the greatest thing since sliced bread, and they will work with you and help you convert. It just brings in and introduces to the equation distractions of time and some cost of money. Sometimes that can go very quickly and very easily, but as an entrepreneur with the greatest thing since sliced bread, you don't need that distraction of converting. So if you can avoid converting, if you're already set up as an LLC, that's perfectly fine. But if you've not yet organized, strongly encourage you to think about organizing as a C Corp. Jason? Can you advance to the next one? There we go. So just in summary, and this might be a bit of an eye strain from there, but there is some overlap between the advantages and the disadvantages of an LLC and a C Corp. There are some commonalities. Biggest advantage of the LLC, besides the flexibility and the ease of setting up and the nimbleness, is that pass-through. And so conversely, probably the biggest disadvantage of a C Corp is that double taxation. But there are ways to deal with that, and it's not as big of a disadvantage as you might think. So with that, back to Joel. Not sure that's what.
Just needs a lawyer's touch. Operator error. Operator error, exactly. Thank you, Bart. That was very helpful. So just in conclusion, if the success of your business is going to depend on raising venture capital, strongly consider a C Corp. If not, an LLC might be the right option for you, but as Bart said, legal advice, legal counsel is very helpful and highly recommended. Finally, I'm going to talk about why this is kind of the closing topic for our first part here. Why Delaware? Why is Delaware such a popular place to incorporate? A lot of reasons. First of all, they have a well-known set of statutes that deal with corporations. They've been interpreted many, many times by the courts, very predictable, very set. There's nothing worse for a client than going into a litigation where the outcome is completely uncertain. It's hard to settle a case like that. It's hard to prepare. It's hard to tell the client it's going to be okay because you don't know. And that's why one reason why Delaware is so great. There's also a robust set of case law interpreting those statutes. It goes back a long time. They have a special court that's set up specifically to handle corporate law cases, the Court of Chancery. Another thing that takes out some of the scariness of the whole litigation process is the fact that these are all bench trials. Means a judge is going to determine it and not a jury. There's nothing more unpredictable in my experience than a jury. So that takes out a lot of emotion. You can be sure that the case will be determined on the basis of the law, not on the basis of what the jury had for breakfast or emotions or which lawyer they like or which lawyer has a better suit or whatever. It's very comforting for clients to go into Delaware. There's also a lot of administrative benefits. It's a very streamlined process to get set up there and to operate. So we highly recommend if you go with a corporation, with a C corporation, Delaware is the place to go. And don't take my word for it. You can understand that over half of the companies listed in the New York Stock Exchange and NASDAQ are incorporated in Delaware, as well as 65% of Fortune 500 companies. So with that, we will open it up to questions and answers. Unlike Calvin's dad, we will not lead you astray. I'm grateful for a wife who allows me to do this from time to time without becoming angry with me. But it's one of the benefits of parenthood from my perspective. I think we have a microphone somewhere that will be passed around if there are questions.
Well, yeah. I'm just wondering, you recommend C Corps be set up in Delaware. What about LLCs? Do you recommend that they also be established in Delaware, or does it matter as much?
It doesn't matter as much for an LLC. Maybe Bart has a different perspective, but I think that an LLC is probably better off being in your home state. Just because a lot of these benefits that we discussed don't really apply to an LLC. Thank you for your question.
Can you talk a little bit about each of those types of entities and how easy or difficult or complicated it is to change to a different type of entity later down the road?
It's just going to take a little bit of time and money, sometimes a lot of time and money. There's Mark. Mark, you missed our earlier presentation where you would not be offended.
Oh, I apologize.
As in-house counsel, I ran that Seinfeld video by Mark several days ago to make sure that there would be no issues with it, and he signed off on it, despite what he may say now.
Well, actually, I was going to say, I told him what he wanted to hear.
Good strategy.
It was absolutely hilarious.
Sorry. So yeah, converting from one to another is it happens all the time, and sometimes it goes very smoothly and without a lot of hiccups. Pete, I think you have some experience in actually going through a conversion during a transaction where, correct me if I'm wrong, that was an unwelcome distraction in lots of cost of mostly time and some money.
Yeah, I had to do it without a conversion, but putting the C Corp at the top, and it was really painful.
Okay.
It was actually the same company.
But you guys would have been better served to have just been a C Corp from the start, correct?
Or in that case, or an LLC, because the company never needed outside funding. Either would have worked. But an LLC, taxes, and S Corp, don't do it.
You were an S Corp.
S Corp.
Okay, stay away from S Corps. I don't know if that answered the question. Was there?
It's nice when the audience's experience matches and supports what we've been saying.
Other question on choice of entity?
So I've heard about starting companies in Delaware for the reasons that you gave, but I've also heard about starting companies in Nevada. Have you heard that before? Could you elaborate a little bit more on?
You mean a corporation specifically?
Yeah, starting a corporation. Like the disadvantages and advantages. You know, I've heard of Delaware and Nevada before. I don't know if there's anything specific towards that. But.
Yeah, so we have one in our portfolio. Are Dan and Wes here? No?
They're coming in new.
Okay, so Phone Soap was started in Nevada, and it used to be that two states in particular raised some red flags, Nevada and Utah. That's no longer the case. Utah has a great culture of incorporating here or starting a business of any entity. And I'm not an expert on Nevada, but it might be the silver standard, whereas Delaware is the gold standard. Pete, please.
I'm not sure more recently, but historically, you had a lot of penny mining stocks in Nevada, and that was loose. If you wanted to do a scam, that was a good place to do one. You could get away with more as opposed to a well-developed set of corporate law. That's probably changed. I mean, states have come up to speed, but historically, penny mining stocks in Nevada and the law that kind of came around to facilitate that. So there were historically some issues, still some reputational issues. It'll raise some eyebrows, not a massive issue, but certainly not like a Delaware incorporation.
Anyone else?
Got one more here, Pete.
So when you're attracting employees and you do the equity for pay type of a thing, is there a little difference in how that's treated from the C corporation to the LLC?
Are you talking about?
Taxes and deferred, consequences for the employees, those types of things?
Right, so with a C Corp, as Joel's slide pointed out, you're going to be able to issue stock options, which is probably just a cleaner way of doing that from a tax perspective in particular. But there is that flexibility in an LLC where you can do that. You just have to, the timing is crucial in an LLC. You would have to get employees what are called founder shares at zero or next to no cost, and file an 83B election if you're familiar with that. We can talk with you about an 83B offline or just Google it. But yeah, so the timing there is crucial. Once a startup is going and in operation, like Noah's startup, Allegra Learning, you guys filed any 83Bs for stock grants? You took founder shares, and now that they have a $500,000 contract in China, there's significantly more value to that company. They can't just grant. You guys are an LLC.
No, we're a C
Oh, you're a C Corp. Okay. So if they were an LLC, they could no longer just grant new employees a share of the company, which you want to do to incentivize everybody to be on the same team, and all these great reasons for incentivizing with equity. But as a C Corp, they have more flexibility there with granting up employee stock options. Anything to add?
I think that also the stock options can be tax deferred to the employee with the C Corp, so that's an added benefit. And again, it's just more complicated when there's an LLC. It's hard to arrange that. Yes.
If you have a family business that's been running as an S Corp for a long time, what are the advantages of moving that to a C Corp?
Do you ever plan on raising venture capital?
Probably not.
Okay, so that's the first thing that you're crossing off of your list. So there's not as much need to transfer or to convert. What kind of a business is it, if I may?
It's a publishing business.
Publishing. Okay. Yeah, and there's, these things were created for specific reasons. An S Corp is called an S Corp because of Chapter S in the IRS code. A C Corp is called a C Corp because of Chapter C in the code. And it's possible that in specific industries there are very good reasons for, are there a lot of other publishers, do you know, that organize as an S Corp, as a relatively small family business?
I don't know about that.
And so as a family business, you're going to probably be limited on the number of shareholders, number of members in that corporation. And so that won't be an issue.
Wanting to move to hiring management and incentivizing them, would that necessitate a move to a C Corp?
I think that you can still grant equity in an S Corp.
Yeah, it's just limited. You don't have different classes of stock with an S Corp, so you can't grant preferred stock to anybody. It's all going to be the same class. That's one limitation, but you can still do it. And they still have the fringe benefits. C corporations, again, will just have a wider scope of the kinds of fringe benefits that would be tax advantaged. Thank you. Those questions.
One more, maybe?
Anybody else?
It's my first time hearing of stock class, different form of stock. Can you elaborate on that? Why would you offer a certain kind of stock versus another type of stock?
Yeah, so when you first organized, you were going to have common shares. And if and when you attract other investors, including institutional investors, venture capital, private equity, something else, they will more than likely not just ask for, but they will demand preferred stock. So an entirely different class of stock, and it's called preferred because it has preferred rights. They might get their money back first. They might have a liquidity distribution that's twice or 3 times or 5 times or 10 times that of common shareholders. It's just a different kind of stock that gives them not just economic different rights, but legal different rights. Which the legal rights have to do with control. So they might be able to say if you're a 5-member board, ordinarily you would set the number of board members based on a pro rata vote. They might say we get to select 2 board members or even 3 board members, which gives them control. And lots of different provisions that can write into a preferred class of stock. So yeah, that's the main thing.
Thank you.
And venture capitalists are always going to want to come in and take preferred stock, and that's one of the reasons why C corporations are preferable.
What do you think about phantom stocks for employees?
Phantom stock? I'm not familiar with that concept. It is great.
Phantom in the right conditions could be a great way to go. You're not actually issuing voting shares, and so it's just another way of providing an equity-like incentive that mirrors as if they had it. Typically, it's a little more appropriate for a cash-flowing, stable business, high-growth technology company on a VC path. You won't often see that option. Just work better because you're looking for a capital gain on some type of an exit event. But for a healthy, cash-flowing, profitable, small to mid-sized business, Phantom can really create a lot of simplicity. You're not bringing on additional partners, additional owners, so it's a good tool to consider. A little bit expensive sometimes to set, not prohibitive, but a little bit expensive and complicated to set up, and you have to go through some regulatory issues to set it up, but a good tool to consider.
Thanks, Pete. One more here.
I'm just wondering, you're talking about that C Corp is the best way to start, but is it a startup, especially if you say you're starting with 2 people, and it's going to be a time before you figure out if it's really going to be successful, and and you start hiring employees, you want to have some kind of legal structure initially, but it seems almost excessive to set up a C Corp at that early stage. Do you recommend you start with an LLC and quickly transition? How do you recommend companies start, or should they, when they first decide, okay, I'm going to start this company, with my friend today, that I start trying to set up a board? I guess I kind of wonder your recommendation on that is.
Yeah, it can seem kind of daunting and like a lot of extra steps early on. One thing we just kind of touched on was that those formalities, they just seem kind of onerous. But in fact, when you follow them, you set yourself on a course of good governance from the very beginning. So it is more work at the beginning, but down the road it may serve you well. Again, if you're going to be seeking venture capital at some point in order to succeed. So there's a way to do it. It is more complicated. Darren, did you have some thoughts about that?
Well, I was just going to add that there are lots of businesses where you would never incorporate as a corporation, right? I mean, as a C Corp. If it's designed as kind of a lifestyle business, where you don't plan on having massive growth, and so you're not planning on bringing in venture capitalists or large funding rounds, and you just want to support a family lifestyle with the minimum kind of overlaying structure, you can absolutely do that. But our focus here is predominantly on businesses that can scale and employ hundreds or thousands or tens of thousands of people. So that's why we would focus in that area on this approach.
And so if you're a service provider of any kind, a contractor, a lawyer, a dentist, a doctor, you run a consulting shop of any kind, LLC is perfectly fine. Or an LP, or a double LP, or a triple LP. Some of these things in this family. But we're talking about companies that can scale, that might need to attract venture capital, that could have a possibility of going public one day. So those are different types of companies than service providing types of companies. Okay, Joel has a lot more really good stuff on intellectual property.
I just noticed that Jason's timer has gone off. Jason, that no longer is official for purposes of my bill.
I'll have you refer to Darren.
All right. So quickly, we'll move through the intellectual property overview. Another topic that LLCs or that startups need to consider seriously at the very outset. Intellectual property can be among your most valuable assets. It can be the best reflection of your goodwill and your reputation, and those things obviously need to be protected. Intellectual property is defined by the World Intellectual Property Organization as creations of the mind. Your IP rights protect your ability to use your creation. It doesn't protect the idea itself. It has to be on some kind of a medium. It has to be a creation of some kind. 4 types of IP: patents, copyrights, trademarks, trade secrets. We'll go through them quickly, and hopefully we'll have time for a couple of questions at the end. Patents, you get the right, you basically invent something, and in exchange for the government granting you a monopoly to use that invention for a period of time, usually 20 years, you publicly disclose that invention. And that's beneficial to the public. Other people can see it, they can build upon it, and it creates a public good. Compared to the other kinds of intellectual property, it will require a more heavy financial investment, depending on the type of patent, whether it's a utility patent or a design patent. Copyrights, we won't spend too much time on. They protect literary, artistic works, original works by an author. They last a very long time, usually for the life of the author plus 70 years. They don't protect just ideas, and there are lots of limits on copyright protection by virtue of the fair use doctrine, which allows people to use copyrighted material or portions of a work for public benefit. Trademarks is maybe more relevant to startup companies, and it's a little bit of a trickier concept. Basically, a trademark is anything that distinguishes your goods and services from those of others. So it can be anything. It could be a picture, a word, a sound, a motion. It could be a smell. Plato recently registered the smell of its product because it distinguishes it from others. And it was worthwhile for it to go through the registration process, which I think is kind of interesting. And as long as you use your trademark in commerce, it continues to be protectable. So it results in an indefinite lifespan. At some point you may decide you want to register your trademark. You get some added protections, but be clear that a trademark does not only exist when you register it. If you use it in commerce, if you use it to distinguish your goods and services from those of others, you have a trademark and you have certain protections that already attach. So this slide is my favorite trademark. This is the Peabody Hotel in Memphis with the duck march, which is trademark, it's a registered trademark. These ducks live on the roof of the hotel. Every day the duck master accompanies the ducks down from their home on the roof in a special elevator, down the red carpet, into the fountain, to the accompaniment of John Philip Sousa's King Cotton March. This whole process is trademarked, it's protected, it's registered as a trademark by the Peabody Hotel. It distinguishes their goods and services from those of others, and it's valuable to them, and they enforce it. It's kind of fun. The last one we have is trade secrets. Trade secrets are basically any kind of information that your company has that needs to be kept secret and that your company will lose value if it is publicly disclosed. This could include inventions that are not registered, that you don't apply for a patent on. Some examples of this are the Coca-Cola formula, of course, which has long been held a secret. KFC's recipe, by the way, if anybody does know the KFC recipe, Bart will pay good money for that. So with that, there's Martha Stewart. The reason she's on there is that she had a little bit of an issue with not understanding the difference between trademarks and domain names, and they are different. They can overlap. You can have a domain name that becomes trademarked if the domain name is used to distinguish your goods and services from others. Martha Stewart registered, she applied for a trademark registration, and she tried to use that application to enforce a trademark against a domain name user who was using Everyday Living as a domain name. She lost because she had not registered her trademark successfully. So, a cautionary tale for one more reason, Martha Stewart. That's all we have right now. Do we have any questions in the next couple minutes about IP?
Seems like, well, at least we were advised before in my previous company that unless we showed that we actively enforced our IP, and we went out there and we tried to enforce it, if we didn't do that, then we probably would have had a stronger, strong argument if the day ever came. Does that make sense?
Yeah, that's absolutely right. If you fail to enforce because they were not protected. Kleenex is an example. Escalators. Escalator used to be a brand. It's now just a generic description of a moving staircase. The way to avoid that is to use your trademark as an adjective, not as a noun. So they should have been very disciplined in saying, here's a Kleenex tissue, instead of here's a Kleenex. But yes, that's right. They have to be enforced, and it takes some effort to do that.
So, as far as patents go, I know that the United States shares some different laws from the other countries in the world regarding patents. How would you work around that? Getting them to recognize patents that are made in the United States or things like that?
Yeah, that's going to be a question for each separate country, but the first step is to get a patent registered here in the United States. Once you have that, it can be a stepping stone to register in other countries to the extent their laws provide for it.
Would it be in the form of like a provisional patent?
That probably depends on the country, yeah. You're talking about the laws of all these other countries. But the first step again is going to be probably to register in the United States first, which again only protects you in the United States. It's a good, you bring up a good point. You can register your patent, but that doesn't mean that someone in China is going to acknowledge your patent and not use it there. Anybody else? All right. Thank you very much. Appreciate your questions and your attention.
Thanks, Bill.